Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha. I head up brand awareness at Reveal. On each episode of eDiscovery Leaders Live, I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. Our guest on this episode is Michael Blank. Michael is a corporate counsel in charge of eDiscovery at Dish Network. Michael, welcome.
Thank you, George. Thank you for having me.
I'm glad to have you join us today. You have a topic near and dear to your heart or loathed and despised. I don't know which it is. We'll get a better sense of that as we go. Privilege logs.
Yes.
So tell me, first and foremost, why do you care about this topic so much?
I think it is the area of eDiscovery where courts are most behind. It is also, I think, one of the most expensive portions of any case that is the least useful. I have had a number of experiences both at Dish and as outside counsel dealing with privilege logs and privilege logs challenges. It is, I think, among the most frustrating areas of the law that I deal with.
And you were, as we were waiting to start today, you were just describing to me one of your nightmare scenarios from when you were corporate outside counsel.
Yes. I had a case where we had upwards of 800,000 privilege log entries. These entries, we were in the Fifth Circuit, which has a bad case about email itemization. And so we were itemizing every email in the email chain. It was a lot of manual work. The technology, as I said, was not what it is today in terms of the ability to capture lesser included emails. And it was a real nightmare of a case.
That has to be an extreme situation, and that many documents.
Yes, for sure. It's definitely an outlier, but I think 10,000 or even 5,000 is not unheard of, and even that level of logging is incredibly burdensome and not really all that useful in my experience.
For those who haven't had the opportunity to experience that set of circumstances, describe to them what it's like.
Well, so it really depends on your custodians and what's at issue in the case. But in general, right, if you go through this review process, presumably you've run either manual reviewers or TAR or something across the population to get to a responsive document population. You do a privilege review. Privileged reviewers are often reluctant, especially at first level or second level, to code things not privileged if there's any sort of indicia of privilege, which means that really it's the logging process where you start to really dig into some of the thorny privilege issues of a case. There's often quite a lot of downgrades. And then you make a decision about how your log is going to go. And I'd say the most common is a pick list, where reviewers are picking different, document categories and descriptions to create a sentence that describes the document without revealing its substance or the privilege underneath. It's by far the most expensive portion of review. It takes the longest time. It involves the most sensitive documents in your case, almost always. And then you spit out something that is almost incomprehensible, send it over to another side, and await their challenges.
What sort of challenges then do they come back with?
Well, that really varies, right? I mean, I've had cases where people, might allege in-house counsel can't create privilege. I don't know where they get that, but it's a challenge that is up quite a bit. You get challenges on the sufficiency of the log description, right? Maybe it's too vague and doesn't provide the level of information that someone is looking for. Maybe there's too many recipients on the document, and they say sending the document to this many recipients destroys confidentiality. There's sort of all sorts. I'd say the most common one that I've seen recently deal with collaborative platforms and documents that are stored on collaborative platforms. You often don't have the same type of metadata that courts purport to require out of documents that are privileged. So you might not have an author, you might not have a sender. The document might be stored in a centralized location that lawyers have access to. And so, the same indicia of privilege, the metadata that courts require just aren't available on collaborative platforms.
I think you'd mentioned a relatively recent case, out of the Western District of Pennsylvania, that highlights some of these issues.
So yeah, it's actually, there's the Western District of Virginia
Okay.
last year. It's called In Re Subpoenas. It's got a bunch of subpoena numbers. Folks can go look up. But essentially, it is a case where the federal government sued a pharmaceutical company to enforce 36 different subpoenas, and the pharmaceutical company provided a privilege log with just over 3,600 documents, I think. And the government came up with 4 different challenges to this privilege log that I think really exemplify sort of some of the esoteric nature of privilege logs and why they're so difficult. So the first is the email issue that I mentioned earlier. Privilege log that the pharmaceutical company provided listed several documents as chain emails. And the government said, well, we don't know what's in these chain emails. There's a 1-sentence description. What if there's 36 different emails in the chain? And the court agreed and said, no, we can't list things as chain emails or email chains. You, the pharmaceutical company, must provide a new privilege log where you go back and list every email in the chain. They also challenged the use of the words reflecting legal advice. So this is something you see all the time, right? How do you describe the legal advice that's in an attorney-client privileged document? Is it containing legal advice? Is it discussing legal advice? Well, this company chose the words reflecting legal advice. And the court said, no, that's too vague. Reflecting legal advice. You need to go back and
so would it have been sufficient for them to go back and just change the word reflecting to containing?
Yes, that's exactly what the court ordered. You, the pharmaceutical company, must go back and change the word reflecting to containing. There were also documents on the log that were described as prepared at the direction of counsel. And the court said, that's not really a privilege standard. So you need to then clarify, does prepared at the direction of counsel mean they were necessary to the provision of legal advice? Or do they contain legal advice? Or do they discuss legal advice? You need to go back and remove these words at the direction of counsel and describe them in terms of legal advice. And then the last one was the collaborative platforms issue. Was they had a set of documents that were non-communications, right, from centralized repositories, and so they had described these documents as being from centralized repositories. The court said you need to provide author or custodian information for these documents. It's not enough to list them as these centralized repositories. So those 4 issues, I think, really sort of spell out, right, the nitty-gritty of the language that you use in these little sentences really matters to some courts, and they might make you go through a full exercise of relogging just to change some little language. The email issue is one that has been around for a while, right? And this is courts who fail to they still analyze these issues under the terms of, is an email like a meeting or is it like a letter? Right? And if it's a meeting, then you can describe the meeting, the exchange between the individuals, in one sentence. The meeting was about X. But if it's a letter, then each letter is its own separate thing, and you've got to describe it separately. I mean, God forbid these courts deal with IMs or text messages or chats or whatever it is they have to deal with next, because if they can't deal with emails, then who knows where we'll go next. But clearly the emails are still an issue. There was a case just 2 weeks ago in the Eastern District of Pennsylvania against the city of Philadelphia that also dealt with the email issue and required the city of Philadelphia to relog, I think it was 6,000 emails to list out, to itemize each email in the chain.
It seems to me that that's an especially challenging way of looking at things, because an email or a set of chat messages could be a meeting.
Yes.
An email certainly can be the functional equivalent of a letter.
Yeah.
Then it can be yet other things.
Yes. I think it's a really limiting way to view it. And it sort of depends on the style of communication, right? So a lot of emails I received from outside counsel, for example, are essentially memos in email form. They're letters. They're providing me with a list, of legal advice. The emails I have internally are a lot more like chat messages, right? They're it's a lot more like a meeting. We're engaging in some short text back and forth. So might you log one way and one the other way? I'm not sure that's a really great way to deal with it either. I think finding some sort of standard is probably the best way, but I think even now the technology to capture lesser included emails in an email chain is pretty tough in terms of logging standards.
The Rules Committee
Yes.
has some proposed changes to theoretically improve this situation, no?
Yes. So the Rules Committee has, in their wisdom, infinite wisdom, proposed two changes to one to Rule 16b3 and one to Rule 26f3 to get courts and parties to discuss compliance with the privilege logging rule 26b5 early, right? So in the case management conference or in the scheduling order. To me, this is sort of maybe not going far enough to solve the problem because there are no proposed changes to the actual privilege logging rule 26b5. Encouraging early discussion is great, but I think there are a couple of issues with it, right? Number one being it assumes that producing parties have knowledge of what's in the documents at the time of those discussions, is a misapprehension by requesting parties and from some courts that producing parties just know what's in the documents that early. And I think it also doesn't deal with asymmetric discovery, right? This idea that we can confer early and make agreements when one party isn't going to have the issue and so isn't necessarily incentivized to accept creative solutions.
So I gather that you're not an ardent fan of the proposed changes.
I don't mind the changes. I don't mind suggesting or requiring early discussion of the methodology for complying with the privilege logging rule, but I don't think it goes far enough. I don't think it actually solves any problems.
How far should it go, potentially?
Yeah.
What will solve the problems?
I think we've got to come up with some more creative solutions. The rule already has, so Rule 26b-5, which was added, I think, in 1993, the advisory committee note to that rule already, suggests, right, that there might not be a one-size-fits-all solution. I don't know that courts have necessarily taken that guidance to heart, especially, courts that still require email itemization or document by document logging. The modern sort of inclination seems to be towards categorical logging or metadata logging or categorical plus metadata logging. Um, I think that still falls into the level of, I question just how useful it is. So, when I think of ways to improve, I read the advisory committee note. The draft advisory committee note to these proposed changes suggests rolling logs. Well, rolling means something in particular, right? When we're dealing with document productions. So I'm not sure that actually solves the problem. I think it probably causes more problems than it solves because you have finite resources in a document review, and pushing your best reviewers towards logging while the review is going on means that your underlying privilege determinations aren't going to be as good, and means that your log probably isn't going to be of the same quality. Tiering, on the other hand, tiering of privilege logs might have some use, right? Because the idea being that you put forward something that's very easy up front for the vast majority of documents that you're withholding. So if you're withholding, say, 3,500 documents and you provide metadata for those 3,500, well, that's relatively easy. And then you could allow for some sort of challenge system where instead of dealing with 3,500 documents, maybe you can get down to a discussion about 100 documents or 50 documents, right? What is actually going to be at issue so that you can start to have the substantive discussion and spend your time a little bit more wisely.
So you would give me the metadata information about that entire group. I would go through that, and then I would come back to you and either based entirely upon my own assessment or based upon some form of agreed upon criteria, I could come back and say, for this group, I want more information. Is that the idea?
Yes. Yeah, I think so. Several ways to go about that, right? I mean, either I could require you as the requesting party to come challenge me about specific documents, or you could come to me and say, what I'm really interested in here are documents that you exchanged with this party, right? I'm really interested in this party. And so can you give me documents about that? The other idea, right? And I took this a little bit from government taint teams, which I'm not going to get into whether the government's okay doing that unilaterally in the way they do, but in a situation where one might agree to the existence of a taint team between the parties, it would be similar to asking the court to do in-camera review, but probably a little bit cheaper and a little less, tax intensive on the court. But you could get a neutral third party, right, to look at a set of documents and make a determination on privilege. Could even get a neutral third party to weigh in on the privilege protocol, to weigh in on the process by which you review privilege so that the parties can reach some agreement before the log is ever created on the process for determining privilege as opposed to the log after the fact.
I assume in that situation, someone would have to come to an agreement, or the court would have to issue an order as to who was paying how much of that process for that process.
Sure. I think that's probably right. I mean, I'm thinking of it in terms of like you could put that in an ESI protocol in the same way that we put certain alternative logging proposals in ESI protocols right now.
Yep. Have you seen either of these approaches attempted?
I've not seen a taint team approached outside of the government context, although I get outside counsel coming to me all the time saying we should offer these documents to the court for in-camera review. And my suggestion is always, I don't think the court really wants to engage in in-camera review.
Well,
So,
yeah. Do you know of any judge who looks forward to the possibility
no,
of conducting an in-camera review of
right.
potentially privileged documents?
So, in having discussions with, in particular, at some conferences with requesting parties, it seems to me like they have ideas about how privilege should be determined, and particular privilege experts whom they respect, and it feels like there should be a way to reach some level of agreement on that. um, the tiering approach I have seen, right, usually in the context of metadata logs, as I said, that particularly in cases where you have 10,000 plus privileged documents in some of the big document intensive cases. Um, Metadata logging is a really easy way to provide a lot of information about a document without expending a lot of effort in review. Um, really the effort of just reviewing the metadata for privilege. So looking at file names, looking at email subjects, and making sure that you're not inadvertently revealing privileged content through the metadata. Um, but really, that first proffer provides a lot of information that can allow for discussion, whether there are third parties on the document or particular document titles, or categories of documents that folks want to talk about.
Certainly, doing a metadata production,
Hmm.
one might even ask whether it's a metadata dump,
Yes.
is a comparatively easy thing to do. And certainly there's the potential for there to be useful information. How close do you think that is to a targeted production versus how close do you think that is to a data dump?
I think it's depends on how useful the metadata is, right? I mean, so there was a case out of the District of Columbia in late 2022. I think it's called Pietrangelo. It's one of my favorite cases to cite because it quotes Judge Facciola about the privilege log challenges being a waste of judicial resources and privilege logs on the whole being useless. Um, but in that case, the court actually upheld a metadata log very similar to the ones I've seen used, because the document titles provide almost identical information to what you would get out of uh, out of a traditional privilege log. Now, that's not always going to be true, right? There are going to be times where you have document titles that aren't descriptive, document one, or AT0001 or whatever. In that case, a metadata log probably isn't as useful. In certain collaborative platforms, like I said, a metadata log might not actually provide you with the level of information that you're looking for. Um, so, but I do think it's a good first step, right? I'm hesitant to call it a data dump because if you've requested these documents and they're theoretically within the proposed scope of discovery, I, as the producing party, am giving you what you asked for.
Right.
So I
That's
don't
not a
feel
data.
right.
That's
I
not
don't feel all that bad about giving you the documents that you've requested. You could have narrowed the scope of discovery, um, but to me, it's a good first step. And then if there are documents about which you want more information, I think there are ways to go about getting that information, whether it's a description of the shared platform, or providing categories for documents without descriptive file names or email subjects, things like that.
So you've mentioned as possible approaches tiered logging
Hmm.
and a third party team to replace the court in camera review.
Hmm.
What other approaches do you think might be useful?
So, I mean, I think a lot of folks feel that generative AI is the end all be all of the privilege logging process. It shows a lot of promise, right? The idea that you could get the algorithm to scan these 10,000 documents, and in the span of minutes, right, or seconds, however long the tool takes, it puts out descriptions. And you see it already, right? There are plenty of tools that can provide you summaries of discussions. My Google Chat at work does it. If I miss a bunch of chats, I'll log on later and it'll tell me, this is what people were talking about. You see it in case law summaries a lot, right? Folks will have the tool tell you this is what folks were talking about. So it is promising if, right? And there's a couple of sort of caveats there, which is number one, a lot of these tools use the language from the underlying document to create the summary. And that's exactly what you don't want in a privilege log, right? Because you don't
Mhm.
want the tool to actually take the privileged content and reveal it in the privilege log description. It also assumes, right, that the documents that you're logging are text intensive. And like I said, a lot of the harder calls are these emails, with in-house counsel maybe talking internally that are really more like text messages or chats than they are like emails. And there are going to be, right, text messages and chats in there as well. And large language models like a lot of language in order to run their processing. And um, so I'm not sure the tool is there yet, but it's certainly among the more promising developments that we've had. That said, I don't think the forthcoming generative AI revolution justifies not altering or considering changes to the underlying privilege logging rule.
So it sounds as if I'm hearing you correctly, you're saying that possibly Gen
Yes.
AI will deliver a viable way of dealing with this, but let's not hold our breath.
Yeah. I think, we've got to wait and verify before we can trust that this is the true revolution. It's certainly promising, but there are aspects of logging that just aren't going to be solved by that. I think collaborative platforms are a great example, right? I mean, nothing about generative AI is going to solve the problem of not having a custodian for a document stored in a centralized repository.
What about the notion of replacing logs entirely with some sign-off process, for
Yeah.
example?
I mean, it would be great, right? If the court would sign off on the process for logging privilege, or if even you could, get opposing party sign off on the, uh, the rule for privilege that you put in your review protocol. Um, I think, you know, it would be great. It's again in asymmetric litigation, you often don't have the incentive to agree to things like that. And then the question would be whether the court feels that signing off on the process for determining privilege is a legitimate um, replacement for compliance with Rule 26b-5, or whether even if the court signs off on the privilege logging process, do you have to provide some sort of log, in which case, I don't know that you've actually gotten anywhere.
Yes, because I can draft up a process
Right.
that can look great on paper or electronically.
Hmm.
It doesn't mean that I run the process effectively,
Yes. Or that the
nor does
people that you've used to run the process have actually applied it in the manner in which you've contemplated.
nor I would assume does it mean that the process can work universally.
Sure.
So it sounds like that's a challenge as well.
Yeah.
So where does that leave us?
Think it leaves us in, the gray area. I don't know that the rules committee is coming out with anything to come and save us. It seems like they're going to move forward with these sort of small changes. You've still got courts who don't apply the rule as written, as we've seen, I think, with the email messaging issue. So I think it leaves parties in with the responsibility to sort of take control of the issue, start putting it in your, ESI protocols, start contemplating it early. If you have in-house counsel in your, list of custodians, that's something that you should be contemplating. And thinking early so that you, as the producing party in particular, can bring forward some suggestions that might be palatable to your opposing party.
And it sounds as if, as with so many areas of e-discovery, when you've got opposing parties involved, discussion and early and often might be a useful part of it.
I think that's right. I mean, I again, whether the opposing party has the incentive to agree to anything less than what they think they're owed, you know, you'll have to see. But I think bringing forward those proposals makes you look reasonable if there is ever a challenge in front of a court that you can say, but we tried, and here's what we tried. And I do think you'll start to see more scholarship on this issue that provides some guidance about alternative ways that you can approach things that are a reason to provide the level of information that you're required. I still don't know that it's going to be actually useful, but you can comply with the rule in a way that's maybe a little bit less onerous.
Well, Michael, you've given us more than a little food for thought when it comes to privilege logs, the challenges and potential ways of addressing us. Thank you for those insights. Michael Blank is Corporate Counsel, eDiscovery at Dish Network. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. Michael, thanks so much for joining us today.
Thank you for having me, George. It was a pleasure.
Likewise.